All right, guys, we are back and we are going to talk about human rights law today. So, got to talk about where this stuff comes from. The oldest set of laws we have on record are from a place in kind of what is now the Middle East. And there's the law of, and I'm sure I'm mispronouncing this, Urukagina of Lagash, right? And as you might expect, this is a fairly basic set of, if you do this, this is what your punishment will be kind of laws. And interestingly, from a human rights perspective, we begin to see even the very earliest kind of definitions of humanity that, let's just say, will plague humanity and still plagues humanity today. One of the good examples from this very, very early code of laws was that you could punish women for adultery, but the punishment for men was basically non-existent. So if a husband and wife both cheated on each other, the wife would have a strict punishment, the husband would have little to no punishment. So that's a good example of the early division of humans by, in this case, gender. But then, of course, there's always, class and race and religion and all those other things that have divided humanity and what constitutes human rights since essentially the beginning of civilization. The Code of Hammurabi comes around a few hundred years later. At the time it was found, it was the oldest set of laws we had ever found, and a lot of textbooks and websites still refer to it as the oldest code of laws we've ever found. It's actually not anymore. We found, I think, 2 or 3 that are older. But it's still a really famous one because it was, there's a big giant stone with this whole thing, and it's very pretty, and it's hanging out in, I think, the British Museum now. And that was when it was first found. That's what they found it on. So it was very kind of a flashy thing. It made big news, and it was a kind of a big deal. Excuse me. So, but in the Code of Hammurabi, we again see that the punishments are different based on not just gender, but also class now. In Hammurabi's time and in his area, which is still the Middle East, there were kind of 3 ranks of people. There was the property owners at the top, the freemen in the middle, and then the slaves at the bottom. So your punishment varied whether the victim was in a class higher than you, the same as you, or lower than you. So if a property owner killed a slave, the punishment would be a minor fine. But if a slave killed a property owner, it would be, death. On the other hand, it does kind of acknowledge that people have a right to property. That is one of the most basic human rights. Remember, Locke was the guy who said, we only have 3 rights: life, liberty, and property, right? While the Code of Hammurabi would maybe a little light on the first 2, but it definitely recognized that right to property. It also allowed women to divorce husbands in certain very limited situations, but that's a lot better than a lot of other cultures did in the past and even to this day. So that was kind of a forward progressive thing for 2,000 years ago, or 2000 BC, I'm sorry, 4,000 years ago. The next one that comes up is actually a fairly controversial one. There's this thing called the Cyrus cylinder, which was found in what is now modern-day Iran. And it was basically, it has a set of kind of royal edicts, which are, essentially laws. But most of it is kind of almost like a history of this guy Cyrus who killed the former king, and this whole cylinder is talking about how, well, Cyrus is great and he's wonderful and we love him, and he killed our old king who was terrible and we didn't like him. And it's kind of unclear how much of that is true and how much of it is just propaganda trying to make the new king happy. But one of the things it does lay down is that the people in Cyrus's domain enjoyed freedom of religion. So Cyrus didn't care if people were Jewish, because the Jewish religion was around at the time, or any of the other existing religions that were in that area at the time. Obviously, Christianity and Islam had not come around yet, but there were still many religions in that area, and Cyrus essentially said, anybody of any religion can live in my kingdom and be prosperous and all these things. The Talmud, as I referenced in the last section, what the Christians call the Old Testament of the Bible, that laid down a lot of laws and ways of acting that don't explicitly call themselves human rights, but they kind of implicitly acknowledge that human rights exist, such as, thou shalt not kill, which is one of the 10 Commandments from the Talmud, kind of implicitly implies the right to life, right? So that was a very important, thing to acknowledge back then. This is, kind of the very beginning of human rights and how we treat each other in civilization and all these things. We'd only invented agriculture not that long prior to when these top 4 things were written. So it's kind of a big deal to once we've developed such a civilization, we have to sit down and really figure out exactly how we're going to treat each other. And these are all really good examples of how that works, okay? We move out of the Middle East and over to kind of South Asia, modern-day India kind of area, and there was a ruler named Ashoka who, like Cyrus, said, people of any religion are free to live in my kingdom, and we're not going to discriminate against you, whether you're a Hindu or a Jainist or whatever. I don't even honestly know what most of the religions were back then. I should probably research that. But Ashoka also said that cruelty is prohibited against both humans and animals, which is kind of very, very ahead of its time. We don't think of kind of cruelty to animals being a big deal up until really the modern day, most of us, right? But even going back to the Talmud, the entire kosher way of eating, part of that is designed to limit the suffering of animals. So these ideas were being, at least being written down. We're not sure how well that actually worked in practice, but at least in the letter of the law, there were rules against treating animals cruelly and treating people cruelly, and we have to treat everybody with religious tolerance and all those things. Fast forward a little bit and to focus on kind of Europe, because once again, this is the kind of academic area where most of the research has involved the West. For a long time in England, the king's word was law, right? I mean, the king could do essentially whatever they wanted. There was basically zero restrictions on what the king was allowed to do and what the king wasn't allowed to do. But then in 1215, a group of nobles got together and forced King John to sit down and sign this document that they called Magna Carta. And this was the first major push in kind of that Western common law, English law kind of area that said, look, the king's right is not absolute. There are some things the king can't do. There are some things that are too far, even for this king, who, again, back then, they believed the king was ordained by God to rule over them. And so for people to come together and say, we know the king has been ordained by God, but even being ordained by God, there's some things that he is not allowed to do. Some things that are too far, even for the king. So notably, these rights that were spelled out in the Magna Carta didn't apply to everybody. They were only there to protect the nobles, right? The land owning elite of the English kingdom, right? These laws didn't protect the peasants and the common people and anything like that. It was only to protect the nobles from the king. Most importantly, the most important rights that were kind of first recognized here, at least in England, are the rights to due process. And due process essentially just means you have to follow the rules of how to do things. If somebody's entitled to a trial, you have to give them a trial. You can't just skip that part. If someone, by law, it says they have to have a hearing in front of this, and they have to be able to present evidence in their favor and all this, you have to follow those rules. That's essentially what due process means, right? You have to follow the rules. You can't just do away with all those processes that people are supposed to have by law. And then there's habeas corpus, where habeas corpus is still a modern legal tool in the American court system. And essentially it means a writ of habeas corpus essentially means, look, I believe my imprisonment is unjust. I believe this imprisonment is against the law, or I'm being cruelly treated, or there's some reason why I shouldn't be imprisoned either the way I am or at all. So if you write a writ of habeas corpus, that the sovereign, in England obviously it was the king, these days it's the Supreme Court, you're entitled to go in front of a judge, in front of a neutral magistrate, and plead your case and ask them to release you. Okay? But again, this applied only to the nobles in England. Wasn't until 1688 that the English finally got some rights for kind of normal people, the peasants, the everyday life. And in that case, first they acknowledge that the monarchy is not absolute, right? The king has some restrictions on what they can do and what they can't do, not just with the nobles, but period, with anybody. And it also, for the first time, guaranteed the right to vote, right? Because at this point, Parliament existed, but it was relatively powerless. They had a lot less power than they do today. It was still mostly ruled by the king. Today, the vast majority of power is held in the House of Commons, which isn't even all of Parliament. It's just their half of Parliament that is actually voted in. Their other half of Parliament, the House of Lords, and the Queen, as we have today, at least as I'm recording this, the Queen and the House of Lords have very little power compared to the House of Commons and the Prime Minister. And this English Bill of Rights of 1688 was really the beginning of that, right? We want this House of Commons to be representatives of the people, and thus we want to be able to vote for them, right? Fast forward 100 years, we get the American Constitution, which once again, because of people like Thomas Paine, who we talked about in the last section, they wanted to put down some positive rights. They wanted to list some of the rights those American people have. Now, looking back on this 250-ish years later, we can see that these rights, when they were written in the American Constitution, really only applied to some people, right? It was essentially white men. And not only that, but landowning white men. Those were the ones that these rights only applied to that group when the Constitution was originally written. And it's taken the last 250 years to the point where now we've kind of acknowledged that no, rights belong to other races, especially African Americans and Native Americans, and to women and to non-landowners. But that writing down that the Bill of Rights, those first 10 amendments, were so incredibly important to kind of positively acknowledge, look, these are human rights. We're putting this in our foundational country governing document that these are rights. Okay? About that same time, the French Revolution happened, and in 1789, the French had their own kind of version of the Bill of Rights. It was called the French Declaration of the Rights of Man. Okay? And these are still followed to this day. They're still part of French law, although obviously at times they were kind of ignored, especially during the Napoleonic era. But interestingly, similar to the American Constitution, this French Declaration of the Rights of Man distinguished between kind of active citizens and passive citizens. Now, what does that mean? It means essentially the same thing that the American Constitution meant. Active citizens are the landowning white men, and the passive citizens are kind of everybody else, right? And obviously, these rights are much more applicable to the active citizens than the passive citizens. And like the American Constitution, they have changed a lot over the past 250 years, to the point where it's much more of an equal, those rights apply much more equally than they did when they were written. Okay? So, here's the beginning of what we're going to go over in the next subsection. And that is essentially, how does this go now from the American Constitution recognizing certain rights and the French Declaration of the Rights of Man recognizing certain rights? And, those only apply in those countries, right? So my American civil rights are only recognized by America. If I travel to Brazil, I can't expect that the Brazilian government is going to recognize those rights in the same way that the American government does, right? So kind of the next step in this is international law. How does international law treat rights? And international law is really kind of a relatively brand new kind of area. It's an entirely new thing. In the scale of human history, international law as a concept happened, yesterday. So a lot of how international law is supposed to work and whether it's even feasible or not comes down to what we talked about 2 sections ago, i.e., what is the job of the state? And again, I'm not using state to mean like American state. I mean like national government. What is the job of the national government? And that depends on who you talk to. There are many, many, many different kind of views on this, but we're going to talk about 3 of the bigger ones. The first one, we're going to go back to Hobbes. Remember, Hobbes is that guy who's like, mankind is in a constant state of warfare, and we create the state to mitigate that warfare and make us get along. And so we're giving up some of our rights to the state so that they can give us security. Okay? The thing we expect from the state is security. We don't want to be the victims of crime. We don't want other countries to invade us and murder us and take all our stuff. We don't want our fellow citizens inside our country to murder us and take all our stuff, right? So we're giving up the freedom to murder other people and take other people's stuff to the state so that the state can protect us from having other people do that to us, right? It kind of the modern version, what Hobbes's philosophies have kind of morphed into is a thing called realism. And realism essentially sees international law as unfeasible because each nation state is kind of looking out for its own. The people have given those rights to their nation is there to protect them. Nations are thus going to be selfish, if you will, right? So international law is, you can't go anything higher than the state. There's no authority higher than the state, thus states cooperating with each other is kind of useless. But then we switch to the liberals. And remember, I'm not using liberal the way that kind of modern American people use liberal. I'm using liberal in the old school philosophical sense. Um, so there's John Locke, John Stuart Mill, Adam Smith, the founder of capitalism, those kind of guys, right? Their focus was all on economics, right? Economics, economics, economics. Um, and they look at international law and they say, look, international law is great, but it has to be about consensus, and it has to be states agreeing to get along and agreeing to abide by these rules that will then help the economic system and allow trade and allow all these voluntary transactions that humans really love to complete with each other. And that should be the goal. Again, minimal government, just kind of make sure that these voluntary transactions are done according to their contracts, and that's it. That's the only job of government, and thus, if international law can help that, if two countries can come together by consensus and help that process, great. Then there's Marx. Karl Marx, the whole communism guy. And he also sees it as economics. He sees, his focus is also economics, but he's coming at it from a much different direction than the liberals. The liberals are saying, economics good, that's how humanity works. The government's job is to ensure that. And Marx says, yeah, economics is the focus. It's the government's job to ensure that those economic interests stay stable, and that's the problem. It's that government only cares about the rich. Governments only care about the capitalist class, i.e. those with the money, right? So Marx looks at international law and he says, essentially, this is not a meeting of equals, right? If the United States and Jordan get together and try to create an international treaty, that's not a meeting of equals. The United States has all this economic power. Jordan has comparatively very, very little. And it's not just that, that's not a coincidence. Some countries are rich because others are poor, and the other way around. Marx was looking at the kind of history of colonialism and exploitation, especially by countries like the United States, England, France, Belgium, around the world, to kind of take their wealth and steal it. I mean, not to sugarcoat it, but I mean, that's essentially what these giant Western powers did for hundreds and hundreds of years, especially in Africa and South America, places like that. So Marx says, look, international law isn't this meeting of equals that people are trying to make it out to be. There's the haves and the have-nots, just like within any capitalist system, but on a bigger scale, right? So international law is going to be dominated by the rich, and the poor are going to be ignored. But we will talk more about the actual attempts at international law in the next subsection. I'll see you then.